Good afternoon. This is Laws 11046 and 19038. That's Planning and Environment Law and Law in the Environment, Central Queensland University, Week 6. Tonight we're very privileged to have as our guest Mr. Rod Litster QC. He will be primarily talking about the decision of Prettejohn against Cairns Regional Council. That's a decision of 2012, QPEC 23, Judge Everson presiding. But we will also invite Rod to speak more generally in terms of the life of a barrister and the way in which the Planning and Environment Court operates in Queensland in particular. So thank you very much, Rod, for doing that. Just by way of introduction to the case of Prettejohn against Cairns Regional Council, this involved a decision where Judge Everson had to consider a rejection of a planning application which involved a large site of land in low-lying area at Trinity Beach. The applicant sought to develop the land even though there were substantial conflicts with the 1996 scheme at the time. But at this stage, if I could invite you, Rod, to perhaps speak about the case if you wish, and then if you wish more generally about life at the bar and Planning and Environment Court.
Okay, well, look, I'll talk about the case primarily because there's a lot that can be said about it. It is a case which you don't get too many of these days, and the reason that I say that, and this is relevant to the topics that you've been asked to discuss as part of your course, the legal rules that are relevant to this particular case are somewhat complicated by the fact that this was an application that was made at the time that the Integrated Planning Act 1997 was in force. In other words, it was an application that had originally been made prior to December of 2009 when the Sustainable Planning Act came into force. The rules that then operated required that you have regard to matters that were dealt with under pre-Integrated Planning Act planning schemes. You were required to deal with them under the rules, the decision-making rules that applied under the Local Government Planning and Environment Act 1990. So what we ended up having to look at in running this case was we had to firstly go to Section 819 of the Sustainable Planning Act, that then took us and explained that we would deal with it as if the Sustainable Planning Act had not come into force. And then we looked at, well, what did the Integrated Planning Act require us to consider, having regard to the fact that the 1996 planning scheme was the scheme that was operative at the time that the application was originally made. Subsequent to the making of the application, there had been two planning schemes come into existence as well. So one of those had actually expired by the effluxion or by the introduction of the second. So what we had was we had a 1996 planning scheme which incorporated a development control plan and a strategic plan. We had a 2005 planning scheme, and we had a 2009 planning scheme which was a modified version of the 2005 planning scheme which had been brought into existence at around the time that SPA, or the Sustainable Planning Act, was coming in. So against that complicated background, the judge was required not only to look at the law as it presently stands, or presently stood at the time when he was deciding the application, but he was by law required to consider it against a set of rules that had long since ceased to operate or exist for any other case, or other cases other than ones that fell within this particular framework. The consequence of that is that he relied very heavily on the 1996 Development Control Plan in deciding the case, and we'll come to some factual matters at a later point in time. And he also had to rely on the decision rules under the 1990 Act, which required that where there was conflict with a relevant strategic plan or development control plan, then the decision must be one by which the application was refused, unless there were planning grounds sufficient to justify the decision. Now, you'll notice that I emphasised the word planning. That is because under the current rules, the question for overcoming conflict is one of what are grounds for overcoming conflict, not planning grounds. So the decision process changed between these various acts. I don't think in practical terms there has been that much difference, but grounds, of course, are now specifically defined under the Act to include any matter of public interest, and it doesn't include matters of the particular interest of an applicant or some other person, financial or otherwise. So that was another distinguishing feature in this case. Just then turning briefly to what happened, this development was a development of Taylor Point, which was one of the last undeveloped headlands to the north of Trinity Beach. It had been the subject, I think, of an earlier decision. I have a recollection, and I just didn't have time today to go and search out the history of it, but there was an earlier Prettejohn decision against Mulgrave Shire. I can't recall whether that was this site or another site that Prettejohn developed, but there were certainly other cases involving this site, and there had been a lot of community interest in ensuring that the site was not developed. Hence the fact that, although not recorded in the reported version of the case, the other parties, the submitters, were in fact represented by the Environmental Defender's Office, and there was a solicitor advocate who appeared for them and made representations and cross-examined on their behalf. So it wasn't just a case of an applicant appearing and arguing the case against the council. There were other people who were involved and interested in the outcome of the case, and they made their submissions and they actually called evidence. It was an interesting scenario in terms of the evidence, because the witness that was called on behalf of the submitters was indeed one of the submitters personally. So an interesting question arose about whether or not that could give rise to a conflict of interest. It didn't need to be determined at the end of the day, and that wasn't the subject of any determination in the hearing, but there was certainly some submissions made that perhaps his evidence was not as telling as evidence by independent people who were otherwise retained independent of any particular interest in the case. So then going to some of the material facts, perhaps I should just cover off on a couple of the things in connection with the statutory instruments, as well as the three planning schemes that I've referenced, 96, 2005 and 2009. There was also the Far North Queensland Regional Plan that was brought into existence, and the Far North Queensland Regional Plan was introduced not that long out from when the case actually came before the court. The consequence of the relevance of these later documents is discussed in the judgment from about paragraph 30 and onwards, because under the rules in play under the Integrated Planning Act, the court was obliged to give weight to any new laws and policies that the court considered appropriate. So it wasn't just going to deal with it on the basis of the old planning scheme. It was obliged to give some consideration to whether it would give any weight to the new provisions. As it turns out, the court gave weight to Cairns Plan 2009 and also to the Far North Queensland Regional Plan, but the primary basis for the decision was on the strength of the conflict with the 1996 scheme. Now, if you were to read the decision, you would be perhaps amused to hear from me that I was never confident that we were going to win the case. I was extremely troubled during the course of the hearing because there were favourable noises coming from the bench in favour of the appellant, where he was indicating, as comes through from the judgment, that they had done a lot that was required of them to, shall I say, tone down the effect of the development on the environment. Ultimately, however, for reasons I'll come to, the court was satisfied that there was conflict. Now, just going then to the instruments themselves, in the in the 1996 planning scheme, there were particular provisions in the DCP which required that the land not be the subject of anything more than minor earthworks, and that there be that the proposed use would not be brought into effect by using complex engineering solutions to overcome constraints on the site. So those two provisions and the need for controls to ensure that there were acceptable outcomes, those three provisions were the provisions that formed the fundamental basis of the court's consideration in the matter. Added to that, City Plan 2009, which came in March 2009, the land had been identified in parts as being unsuitable for development, as well as that in the Far North Queensland Regional Plan, although the land was included in an urban development area. Sorry, my terminology is incorrect. It was in the just bear with me, the urban footprint under that document. That plan was expressed to be the preeminent plan for the Far North Queensland region, and it was to take precedence over all other planning instruments. And that this judge found was a factor that told against the development in this case. I should footnote there that there is a decision of Judge Robin last year in a case called Mackay Shopping Centre and Mackay Regional Council. I don't have the citation handy, but it was a decision delivered in about June last year, which went on appeal, but the appeal was withdrawn. And he disagrees with the approach to the application of the Far North Queensland Regional Plan in the context of that case. So the law, so far as the application of regional plans, is not so clear as one might have thought by reading this case. The evidence at the end of the day as to environmental impact and visual impact was all evidence that it was ultimately in favour of the appellant. The thing that got the council and the submitters home in terms of conflict with the planning scheme was the nature and extent of the interference with the site in an engineering sense. And I'd commend to you reading paragraphs 47 through to 50. The nub of it was that we against that background of the development control plan requiring no more than minor earthworks, the evidence was that there was sufficient dirt to be removed from the site by way of earthworks, that there would have been enough fill generated from the earthworks that the MCG could have been covered fence to fence by a metre. So that's pretty substantial on any view of it. And as a lawyer, that was a pretty nice visual picture to be painting to the judge, that you could dump a metre of soil across the whole of the MCG. It doesn't sound like minor earthworks, does it? So that was a pretty telling factor. The other factors that were telling were the introduction of a pathway that would span some 40 metres of gully, 8 metres above the gully, and it was required. There was an elevated pathway with 5 metre work zone to minimise impacts on vine forest, and there are also significant portions of the roadworks. And this becomes important in terms of the Far North Queensland Regional Plan. The earthworks were required in slopes greater than 1:3, and some slopes greater than 1:4. So they were important facts that came through. At paragraph 53 of the judgment, the judge goes through the tests to be applied, and he there references the decision in Palyaris, P-A-L-Y-A-R-Y-S, and Gold Coast City Council, which was a decision of then Judge Wilson, who of course is now a Supreme Court Justice and was most recently the President of QCAT. And he there discusses the context of planning grounds. Now, I should caution you in respect of paragraph 53 that there is a more recent discussion of the concept of positive betterment as a planning outcome in a case in the Court of Appeal, and I think it's been to the Court of Appeal 2 and possibly 3 times. It's a decision of Westlink, and I think it's Laidley Shire Council. And Westlink was a power generation entity who was looking to establish a facility out at Laidley, and the context of Palliaris was questioned by the Court of Appeal in that case. So don't hang your hat on Palliaris as necessarily good law anymore, although it still has its work to do in part. The judge then went on to refer to Waitman, and also to Waitman's consideration of probably one of the seminal decisions on the question of conflict of planning schemes, which is the decision of Grosser and the Gold Coast City Council. He applies the tests, and he then goes on to look at the nature and extent of the conflict, which is what he's obliged to do. And he there points out in paragraphs 55 and following what views he'd reached in that context. He discusses the fact that, in his view, there would be complex engineering solutions relied on. He discusses the fact that the works could not be described as other than minor, and he therefore determines at paragraph 60 that the nature and extent of the conflict was flagrant, and each of the above requirements were not complied with. So he then goes on to consider, well, what are the planning grounds? And he identifies a number of planning grounds, but instrumental in all of this is his determination towards the end of the judgment at about paragraph 64 that the lack of support for the proposed development in the strategic plan and the DCP was reinforced by the current planning scheme provisions. So he's used the current planning that was adopted in 2009 and the Far North Queensland Regional Plan, which I'll come back to in a moment, to say, well, you might have got a tick on some of this stuff, but because of those instruments as well, I'm just not prepared to find that there's sufficient planning grounds. Now, on the Far North Queensland Regional Plan side of things, that's why the 1:3 and 1:4 provision was relevant, because back at paragraph 37 of the judgment, the Far North Queensland Regional Plan took the view that the development of coastal land, including the subject site, cannot be reconfigured or subject to other development inconsistent with the relevant council planning schemes unless it avoids slopes greater than 1:4 or upwards, and including the ridgeline, unless there is overriding need for essential community service infrastructure. So he didn't find there was overriding community need. He found there was some need for the form of development. And at the end of the day, we're only there talking about 30-odd residential lots. But you couldn't have classed those 30 residential lots, which would have been high-value real estate, as essential community infrastructure. So they didn't get over the line on that point. So, look, that's the overview of the case, and against that, you should be able to probably get some assistance in certainly that early part of your assessment, item 1. And the understanding of the case. As I said, it was a case where the council and I certainly, as their leading barrister, we were of varying degrees of confidence as we went through the case, because it was by no means straightforward. It was a difficult case. It was hard fought, and it was finally balanced at the end of the day. Although I think ultimately the right decision was made. The interesting thing about it is that subsequently, as a consequence of the indications that the judge gave as to the way in which they had dealt with material aspects, a further application was made under the 2009 scheme for, I think, about might have been somewhere between 15 and 20 lots. And that was ultimately approved by the council, and the submitters, although they appealed, withdrew the appeal. And so there is, in fact, now a development permit over the Taylor Point area.
Thank you, Ron. Do you think the decision would have been different had it been decided on the law as it is now in that area compared to the law as it was at the time? I know that the development that you've talked about has been approved, but I'm not sure if that is because the law had changed or legal sentiment generally had changed. Any comments?
Look, certainly public sentiment has continued to be anti the development of that site, evidence the fact that there was the further submitter appeal against the second application, or the more recent application. The law in 1996, the planning scheme in 1996, in my view, was a far more rigorous planning document than the provisions that have been introduced subsequently. I have a personal view that the planning schemes that were introduced in 2005 and 2009 actually made it harder for the council to refuse the development, albeit there were what occurred under those planning schemes was that parts of the site were actually identified as being encouraged for development, and parts of the site that would have been hard to develop under the 1996 provisions, in fact, became easier to develop under the 2005 and 2009 scheme. It's just the way that the planners had dealt with it. They didn't take into account some of the sorts of things that they were required when they were designating the land for the 2005 scheme and 2009 scheme. They didn't introduce some of the tests that that were in existence in 96, and I think they therefore had actually made it easier to get an approval in the later schemes, which is highly surprising. Given that the general tendency is to tighten up development controls rather than lessen them, it's rather surprising. So I think it might have been a little bit easier, and I think that's probably the answer as to why the council ultimately approved something that was less than what they'd applied for when the court rejected it, and they found some support for that in the new planning controls.
Is that partly because the planning law now requires assessment managers to take a greater overview approach? It's less prescriptive than it used to be?
I think that what you've got now is you've got your performance criteria and your acceptable solutions. I can't recall if that's the exact terminology that's used in Cairns Plan. You well understand that there are differences in terminology between various planning schemes throughout the state, but let's call them performance criteria and acceptable solutions. With the performance-based planning with the performance-based planning that now occurs, if you satisfy an acceptable solution, then you get the tick under the performance criterion. And some of the acceptable solutions aren't worded with perhaps the degree of precision that one might like and one might accept. And certainly in this case, there wasn't anything like the requirement under the 1996 scheme where you were not able to develop land where the outcome would be other than minor earthworks or complex engineering solutions. Nothing like that was incorporated into the acceptable solutions. And so I think performance-based planning has probably meant that it's easier in some instances to get over the line. I think that generally there's been albeit a lot of people think that there's been a tightening of control. I think to some extent it's much easier to sell proposals if you're prepared to put the effort in to try and meet the various requirements of the scheme.
Do you think that the general approach to be more holistic in terms of planning from the top down, if I can use that term, works well in practice?
I think in general terms, yes, although there still seems to be an attitude, certainly at state government level, that not enough approvals are coming out. And that's why we're looking at a change in legislation, I think, now. And we are looking very, very clearly down the gun of a change in legislation. I'm told that there will be a consultation draft out in possibly next week, but I suspect it won't be till the end of this month.
Okay.
So there's consultation already occurring about the form that the new legislation will take, and there are certainly edicts coming from the department that it's going to be a much shrunken piece of legislation. I think originally they wanted 200 pages. They're now talking 250, but they're changing the face of planning yet again. So I think everything we talk about will be up for review in the space of the next 6 months or so.
Okay. Thank you. Rod, I'm aware that your time is very limited and we really do appreciate it. I think there are a couple of questions that are coming through. I see there's one there from Anthony. Anthony, would you like to take the floor?
John? Hello?
Yes.
Can you hear me okay?
Yes, we can. Thank you. Yes, Tony?
Yeah, it was just as a matter of interest. The amount of fill that was going to be removed, had the planning permission been granted, it was the same as the square area of the MCG.
Yes.
Yeah. Okay. Well, the square area of the MCG is 20,000 square meters. Therefore, the total volume of the fill would have been 20,000 cubic meters of whatever was going to be removed from the particular area, which would be a very persuasive argument, you know, that amount of fill to be removed was going to take some time. And not only that, but my own consideration would be that it would have left a huge scar on the environment there.
That's exactly right, and that was the critical feature, that it was going to be 19,200 cubic metres of cut and 3,200 cubic metres of fill. So the amount of earthworks balanced across was effectively that 2,000 cubic metres moving of earth around the site. And what he did find, however, was that there'd been a significant attempt made to ameliorate the visual impacts of the scarring on the hill, but the fact remains that there was very, very substantial earthworks. There were rock anchors having to be put into walls, retaining structures up to 6.5 metres high for some of the roads to be built. So to describe any of that as minor was a stretch of the imagination at the best of times. But that only came out as a consequence of the engineering evidence going into a high degree of detail.
Absolutely. Yeah. Thank you very much.
Thank you.
Paul, do you have a question?
And just quite interested to see how they were actually a co-defendant. What was their standing? What was their particular matter that they felt that they could get? Well, they obviously did get standing.
This is the people who are represented by the Environmental Defenders Office. The submitters were a group of concerned residents who lived in the nearby area. Their interests were many and varied. Some of them resided on the roads that would have been used by traffic taking fill to and from the site. They were concerned about that. But this land has essentially been derelict and unoccupied for many years. It used to be used as a church camp for some years before it was privately acquired. The consequence of it being privately acquired is that nobody's actually lived on the site for quite some time, and it's, shall we say, been used by the public for their own purposes, including getting access through the lower sections to the beach. So there were a lot of people who believed it to be somewhat in the public domain, and their complaint was, well, unless there's proper access given to the beach through this site, which was one of the things that was an outcome that the judge relied on as one of the planning grounds. He looked at it as a planning ground, although he didn't find it sufficient. He did consider it to be a ground, was the provision of private access or public access to the beach. So that was the one thing they were concerned about. But generally, there was an overarching concern that the quantity of earthworks was much greater than the developer was stating in the first instance, and that that would result in a much more rigorous denuding of the site than they expected. And so they just didn't want to see that. It was a visual thing. The judge was ultimately satisfied that much of the visual thing was okay, but that's what their particular interests were. So all of these people had made submissions against it. I forget the numbers, but it was probably in the hundreds of submissions, as I recall it. And there were probably 20 or more people who were actively participating in opposing it at the court stage through the Environmental Defenders Office. So that's where I think that their particular interests came in. The person who gave evidence was the president of the unincorporated association that lent its name to the submission, and he was an architect who had for many years campaigned politically about saving this site and getting the site into public ownership.
Thank you, Rod. Now we have questions, and we'll have to be brief on this, from Andrew and Rodney and Anthony. So can I hand it over to you, Andrew, if you've got time, Rod?
Yeah, no, that's fine, John. my other meeting's been cancelled, so,
okay.
So I've got as much time as you need.
All right, thank you very much.
Yeah, Rod, hopefully you can hear me. Just a real quick question. Do you often find that the planners drafting these new schemes are taking in case law? Yeah?
I can't say that they specifically do, but that's mainly because I think sometimes the strategic planners, who are the people who are often involved in the drafting of planning schemes, aren't actively involved in development assessment, and therefore aren't actively involved in seeing what happens in terms of cases that they either reject or approve. Now, my primary involvement with a local authority over many, many years has been with the Gold Coast. I've obviously acted for many other local authorities, but that one I can speak of with perhaps a little more personal experience. And what I have noticed in terms of the Gold Coast Council is that they have taken on board the outcomes of particularly significant pieces of legislation, and they have cast much of what they say about particular topics. For example, floodplain hydrology and the need to ensure that development is kept out of floodplains. A lot of that has been actively promulgated as a consequence of significant cases that they've had. So yes, planners, when they draft the schemes, do tend to take these things into account, and you do see knee-jerk decisions amending planning schemes to overcome what are perceived as inadequacies in planning schemes quite often. When I say quite often, once or twice a year, you might see that sort of thing where a council will get an adverse decision, and the knee-jerk reaction will be, we'll bring in a temporary local planning instrument to cure that problem until we can bring in a proper instrument to deal with the issue, because we're getting an outcome that we didn't anticipate. So yeah, they do take it into account. How much they take into account is a bit hard for me to assess. And the strategic planners aren't always engaged at that coalface level of development assessment. So I think it depends on how good your relationships are between development assessment and strategic planning in a local authority as to whether you see much of that happening.
Thank you very much, Rod. If I may, I think Rodney has a question.
Yeah, g'day, Rod. It's Rodney here.
Yes.
the other thing that we're also doing at the moment is looking at the Vegetation Management Act 13. One that's just coming up. To me, it sounds very much like it's a open season on the colour of brown at the moment for just about anything and everything. And one thing that I can't fathom is one of the leaflets I was looking at, there was a 50-metre rule on land clearing on certain rivers, and they don't say whether it's from the edge of the bank or the middle of the river or 25 metres each side. I'm just not sure. It only says 50 metres within no land clearing within 50 metres, and I just can't understand which way it's pointing to.
Yeah, I'm not overly familiar with that act. In fact, I haven't had a case. Probably not surprisingly, there hasn't been a case that I'm aware of since the Act came in on the 2nd of December. There's certainly, so far as I'm aware, no declaratory proceedings that have involved questions of the consideration of from where you would take the measurement. There are cases in the past that have considered what is a watercourse, what are the bed and banks of a watercourse, and those cases may give you some clue. I would certainly be looking, as a barrister, I'd start looking at the definitional sections and trying to work out whether there was some relatively clear guidance as to whether you look to the centre line of the watercourse or to the top of the bank. And it may not be expressed, but what you'd look to achieve is you'd look to settle on an interpretation of that provision which best responds to the purpose of the Act. And if the purpose of the Act is to protect riparian vegetation, then possibly you'd be tending to go wider rather than narrower. But I've got to confess, I haven't looked at that piece of legislation. I certainly haven't looked at the definitional sections. But if they're anything like earlier iterations of the Water Resources Act and the earlier acts that deal with water and vegetation, Vegetation Management Act, I wouldn't hold out great hope that every question will be answered by the legislation. There'll often need to be an exercise of statutory construction.
Yeah, just some of the looking at some of the changes in legislation that seem to be very, very ambiguous, and even down to the penalties. They don't even, at one stage, it was in one of the acts that if someone did illegal land clearing more than once, they actually lost their lease. But then this has been changed, and so it really doesn't care if you do illegal land clearing once, twice, 3 times. You're still going to own still going to have the lease with very minimal punishment.
Yeah, look, I suspect that that's consistent with the overarching view, current political view, that, I mean, there's a fairly strong bias at present, not necessarily in favour of the environment. So yeah, I suspect what we're seeing is a softening of approach that perhaps hasn't been seen for the last 20-odd years.
Yeah, to me, well, that's what it sounds like to me. When you look at it, it appears to have a scorched earth flavour about it. Yeah, the more green they can get rid of, the more happy about it.
Yeah, I'm not sure whether I'd go that far, but I do think that there has been a marked softening in approach. That's my instinctive reaction to what I've seen about this Act. I haven't, as I said, I haven't looked at it in any detail because I haven't had to. Interestingly enough, we rarely have to consider these acts in a vacuum. We generally consider them as part of a planning case, and they only usually form sort of a very small part of the planning case that we're dealing with. More often, these sorts of considerations come up in prosecutorial type proceedings. You've just mentioned the unlawful clearing type cases, and that's where we tend to find that we get cases that are a bit more determinative of what the Act set out to mean. I can tell anecdotally a bit of a humorous story that many years ago I acted in a matter involving some clearing of about 1.8 kilometres of the Bowley River in Townsville. somebody had stuck a D9 bulldozer down it and cleared it out and made the water go down there a lot quicker in times of flood. And the government prosecuted. This is back in the mid-90s. The government prosecuted, but they failed to prove that the Bowley River was a watercourse in the relevant location by reference to the definition in the Act. So, so
I'm not being derogatory, but it's the blasted law twisters. They try and turn things to suit what they want. But I'm not being derogatory to you or anything like that. But that's just what happens.
No, that's right. That's right. I mean, on my part, if I'm acting for someone who's done something, it's my obligation to try and find a mechanism by which to use the Act against those who are prosecuting. But equally, that became harder and harder, I might say, during the 90s, because there was a marked increase in environmental awareness and environmentally based legislation, and that's now steadily being wound back by the current federal and state governments, because they've taken the view that it's gone too far in favour of the environment and they're pulling it back. And that's just a policy position that, as a lawyer, I don't make any comment on policy. On a personal level, I've always thought that some of the laws, particularly in respect of vegetation clearing on freehold land, I thought was pretty tough going. But leasehold, I can understand there should have been tighter controls, particularly where there was potential for reversion to the Crown. But anyway, I hope that sort of answers your question.
Yeah, well, thanks for that.
Thank you, Rodney. If you can bear with us, Rod, I think Anthony has a question.
Yes.
Yeah, hi, Rod. Earlier you mentioned that a case of the Mackay Council, and I think it was the Mackay Shopping Centre.
Yes.
And that the judge did not see that the Far North Queensland Regional Plan was relevant.
It wasn't the Far North Queensland Regional Plan there. It's the counterpart that's applicable in Mackay. I can give you the case. If you just bear with me a moment, I'll just see if I can pull up the case on my screen here. Just bear with me.
Yeah. On that, if it's the equivalent with the Far North Queensland one, in the case that we're looking at for this assessment, it's somewhere in there. It states that it's the where is it? The plan takes precedence. Yeah, preeminent plan.
Yeah, that was also in the Mackay case. I argued. I was for the commercial competitor in the Mackay Shopping Centre case. I was for the appellant in that case, and we were trying to oppose the introduction of a shopping centre on land that was not otherwise designated. I'll just bear with me a moment. I'm just calling up this decision. Just bear with me. That case is 2013 QPEC 29. The passage that I was referring to, it might take me a moment to find if you just bear with me. I've done a search of the word regional, and it's not helping me because there's sub-regional shopping centres referred to. So just if you, I know what we'll do. That hasn't come up either. He deals with it about paragraph 51 of the judgment, and recounts the submissions that I made, the written submissions that I made, and for reasons that he then goes on to, he says that he's less troubled by it than was perhaps the case in the Prettejohn case. Part of the reason for that is because just as we were finishing the case, when we were literally the day that we were making oral submissions following a 2-week trial, a decision on other land in Mackay was handed down in relation to the development of a Bunnings, I think it was, or a Woolworths Masters or something like that, where the judge in that case hadn't formed the view that the regional plan told against the particular development. So I was sort of a bit bushwhacked by literally the judgment came down the day before I was making the submissions. I've not yet sat down and analysed this, but if you look at about paragraphs 51 and 52 of that decision that I gave you a moment ago, which was 2013 QPEC 29, paragraphs 51 to 52 will give you the answer. I've got to say I still favour the approach in Prettejohn. I think Prettejohn was right in the approach that it adopted, but I haven't sort of revisited this issue. I just simply footnoted it when I was reading the decision. I thought I should let you know that you should perhaps be a little cautious about assuming that a regional plan can necessarily be determinative, given what the judge said in this other case.
Thank you, Rod. And you've been very generous with your time, Rod, but I've got 2 more queued up.
That's okay.
Nehru, now I'm wondering if I could introduce you. Do you have an answer for us or a question in relation to the 50-metre rule?
It's Don Naylor here, John. On environmental issues and this I think might sort of tie over, when you're doing plumbing, on-site plumbing works and so forth, for on-site waste treatment systems, your 50-metre rule normally is from the bank of a creek, river or system, or if it's a watercourse or summer creek, which may only flow in heavy rain, you need to then find the determined point of what you believe is the edge, and then you take your 50-metre rule back from there, and vegetation and so forth can't be disturbed in that area. So I would think that would probably apply to the 50-metre rule of Rodney's. You take it from the edge.
Yeah. Can I say I instinctively I think that's probably right. I was just looking quickly to see if I could pick up the legislation and the definitions while you were speaking then. It's not immediately leaping out at me, I must say, mainly because I can't seem to immediately pick up how the Act was incorporated into the... Yeah, I'm not getting a clear answer straight away, so I probably ought to defer that.
Local government put it as environmental issue as to why you put that 50-metre rule in place. So
yeah, can I just caution this, that just because you do it in a particular way under one piece of legislation doesn't mean that you would necessarily interpret another piece of legislation to be interpreted the same way. You need to, each piece of legislation will be interpreted by reference to its own terms, and if there's a conflict, then you will generally resolve that question of conflict by determining which is the paramount provision. And obviously, if you've got a piece of legislation that's intended to manage vegetation within a framework, then that's going to have more application to the provisions for clearing under that Act than perhaps some other determination in some other piece of legislation. I am looking quickly at the Vegetation Management Act, and there seem to be provision for things called vegetation management watercourse maps and things like that. And I mean, I think it's probably just it's going to be a fairly complex little question to get to the bottom of. So I just caution that you don't just immediately assume that because under a piece of related, development-related legislation, one answer follows. that answer will necessarily follow in some other case related to another piece of legislation. A court would give that pretty short shift if that was the only answer you had.
Right, thanks for that question, Don. And thank you, Rod. Paul, your query relates to how a state government can challenge through the planning court decision made at an executive level. I'm not sure if that's an executive level at state government level or a council level, but if I could just hand over to you, Paul.
Yeah, sure. Thanks, John. Yeah, Rod, Paul here. I was just wondering, I don't know if you're familiar with and I heard it only briefly on the news yesterday about a appeal that was again dismissed in the New South Wales Planning Court. But in the news article, they mentioned that the state government had actually assisted Rio Tinto in appealing the decision of the I'm assuming the approval department, the planning department in New South Wales, whichever one it is. And I was just wondering how that, like, obviously they've ruled that
they have a different separation of powers.
But I was just wondering, realistically, how long can that separation of powers be applied before the government basically throws its weight around and gets its own way?
I think the decision you're speaking about is something to do with one of the Hunter developments, isn't it? Development in Hunter Valley?
Yeah, Northern Rivers Hunter Alliance, Mining Alliance or something challenged it, I think. Yeah.
It's against a coal mining facility in the Hunter, as I understand it. I don't know the details of the decision. I haven't looked at it. I heard something about it on Lateline or one of those shows last night. So I've got very peripheral understanding of it. Can I just offer this sort of general comment? A decision in New South Wales, what you have is the Land and Environment Court, which is a division of the Supreme Court, and they have certain types of proceedings that are brought in that court, which necessarily bring the state government into decisions. And it may be that what happened was that, as I recall this decision you're speaking about, it is an appellate level decision by the Court of Appeal in New South Wales, overturning a decision of the Land and Environment Court. And what I suspect is the scenario is that the state government may well have been the decision maker in the first instance. Its decision was appealed by the interest group that was anti the mining facility, for want of a better term, and that when that decision was handed down adverse to a decision that had been made by the state government, and I think, as you say, I think it was Rio Tinto, wasn't it? Was it Rio Tinto?
Yeah,
the company, yeah. I suspect that what happened was Rio Tinto appealed against the decision, and also the state government appealed. So I suspect that they were just behaving as normal litigants, just as in Queensland, if at a decision of a local authority, let's say in the case of the Prettejohn case that I was speaking of, the decision had gone adverse to the council. Even before we had the decision, it was pretty clear to me that whilst the Cairns City Council was constituted in the way that it was then constituted, if the judge's decision had gone contrary to their views in the matter, they would have taken it to the Court of Appeal if I'd given them advice that there was a legal issue to take to the Court of Appeal. So I don't know that there's anything necessarily odd about what's occurred in the New South Wales case. I suspect that the state government was the decision maker, and that the decision went adverse to the decision maker and also to the mining company, and that each of them, for perhaps different reasons, appealed the decision. Generally, state governments or local governments tend to focus on issues as to the proper construction of the laws that they administer. And so if the state government thought that there'd been a misinterpretation or a misapplication of the law that they were administering, then they would have a legitimate and appropriate approach to appealing to a court of appeal to make good on that proposition, and say, well, look, hang on, the law should be interpreted this way. That the government says that the law should be interpreted in a particular way, of course, isn't the answer. The question is, what does the law itself say? But the fact is that they're entitled and do make appeals or get themselves involved in cases. Sometimes they intervene in cases so that they can make submissions about the context of the legislation that is being debated in the court. And the Sustainable Planning Act and the Integrated Planning Act always made provision for state government to be introduced to any appeal, because one of the requirements has always been that when you commence an appeal in the Planning and Environment Court in Queensland, you've got to give notice to the minister, the planning minister. And that gives the planning minister a chance to review whatever the appeal is and decide whether there's a state interest issue in it and bring it in from there. Does that help?
Yeah, no, that's good. Yeah, it just so it's basically from the government's perspective, it's more a self-interest in understanding why it happened the way it was, and a self-improvement thing, I guess.
Oh, yeah, I wouldn't even put it at that. I think it's, if they take the view that the legislation means something and the court said, no, that's not what it means, they want to make sure that that's not just an aberration of a single judge. They want to be told that by 3 judges of the Court of Appeal, or they want to be told that by 5 judges of the High Court.
Yeah, fair enough, yep.
And if that's the case, they then go and amend the legislation.
Yep, and get their own way, yep, fair enough.
Yeah.
Okay, cheers, thank you.
No problems.
Thank you very much, Rod. We're very grateful for your time. I don't think there are any last-minute questions. It's been, I think, a real privilege to have not someone who just is able to comment about the case, which is the subject of the first assignment, but a QC who was involved in the actual litigation for 2 weeks odd. So thank you very much, Rod. We really appreciate that. So if I could take this opportunity on behalf of everyone to thank you, and I'm sure there'll be many other people who view this through the course online through YouTube and through Moodle. So thank you very much for your time, Rod. And if we can invite you back at some stage in the future, we would be most delighted. So,
well, feel free later in the semester if you think there's something that I might be able to assist with. If I've got the time, I'm happy to help.
Great. Thank you very much, Rod.
Okay.
All right.
Thank you,
I
everyone.
might end the meeting at this stage, so thank you very much.